You can't convince people the sun rises in the west. At least 99% of people you can't, because they see it for themselves.
If a person who has deliberately put information that is harmful and that has resulted in chaos is never truly prosecuted, is never truly brought to the book, then having new laws, making new institutions is not going to solve the problem. The elephant in the room is the government wants to be the arbiter of truth. That's a little difficult to digest. That has never been and perhaps will never be.
You have the right to stand at the street corner and shout about whatever you want to shout. But you don't even have the right to use a loudspeaker. But somehow, on the question of digital space, we seem to assert a right to free speech which extends to a right to amplification. Nobody has such a right. There is no such constitutional right.
Criminal action in India starts with arrest, ends with bail. So, when we are saying criminal law, criminal action, let us be aware of that reality.
I know we're a little late to get started, but I'm excited to deep dive into this bunch of stuff, of course, that's come up in the minister's speech. And I think, I had something completely different prepared, and now I'm going to maybe change tracks a little bit to pick up on some of the themes that we heard from the minister's speech as well. But Alok, if I can start with you, and then Manu, if I can come to you. Help us contextualize the problem a little bit. Yes, we're all aligned and we've all heard, and I think we all agree about the magnitude of the problem that is the regulation of misinformation, hate speech, harmful content online. I think we're all aligned. I think where there is some cleavage perhaps is in what is the most effective path to regulation and governance. I'd love to hear very, very quickly from you, and then Manu, of course, from the perspective of a platform, what the current framework is, where is it that it's most challenging, and maybe we'll pick it up from there.
Thank you so much, Neha. I'll start by, I suppose, picking off from the framing that Mr. Kharge started off with, which is that the problem is not whether somebody is sharing whether India's national anthem actually is the best or not, that it's actually disinformation and malinformation that you want to target. I'll accept that, yes, that is what we actually want to target. And when I say we, I mean as a societal level. And the problem is real. The problem is real of disinformation and malinformation having large-scale societal consequences is real. But why is the problem real? And I think we need to get to about 5 levels of why before we start to getting to the truth of the matter. The problem is real because there are no serious consequences for engaging in malinformation and disinformation. Why are there no serious consequences? Because our institutions don't exist. The institutions are supposed to ensure a harmonious society in terms of acting neutrally, independently, without political pressure or social pressure. They are not. They have rotted away. And why have they rotted away? Because it has suited a sizable section of the political class to have let the institutions rot away. Because it concentrates power in the executive, in the police, to be able to say, I'll take the final call on this. You don't need to go to the judiciary. You don't need to go to any independent agency. And I think this is the source of the problem. In some way, I think, and I was going to cheekily ask the question until Rutuja shut down and said, no speaker is allowed to ask a question. But the heart of the problem, when the minister sarcastically pointed out that even the misinformation bill was subject to misinformation, the answer to that is simple. Why didn't the government put the bill out in the public domain, right? The government's first task could have been, the moment the first draft of the bill is ready, put it out in the public domain. There would have been no misinformation. But the problem does not require only a certain kind of solution. And so I'll sort of end my comments without getting into too much detail, into leaving us with this thought that fixing this problem, there is a hard solution, which is also the right solution. Unfortunately, using the framework of criminal law is the easy solution. It's really easy for the government to do so, but it's the wrong solution.
What is your hard solution?
My hard solution is, why does misinformation land in a certain way? Right? You can't convince people the sun rises in the west. At least 99% of people you can't, because they see it for themselves. But things they don't know about, you can convince them otherwise. Things they sort of believe, and you can sort of tamper with their beliefs, you can convince them otherwise. The real problem at the heart of it is that we have, this is an education system problem. We are not taught to think critically. We're taught to passively receive information. That's not just in the educational system, societally as well. The hard solution is how do you get people to think critically? I'm not saying 100% of the problem will be solved. But if we have to accept the metrics that 90% is better than 100%, uh, at least, or rather 90% solution tomorrow is better than 100% solution 1 year later, I think you will be able to address a large chunk of the problem. You have to take that hard route. That is one half of the solution. The other half of the solution is put the government information out in the public domain. We have killed the RTI Act. And when I say we, I don't just mean any one party or any one government. There is a consensus across this country that let's leave the RTI Act to die. Let the Information Commission slowly rot away. Let us not put as any amount of information out in the public. Let us make it a fight to get a basic bit of information out of the government. And then we'll complain about misinformation. Then we'll complain about why is false narrative spreading. Because you're not allowing the marketplace of ideas to flourish. When you're not allowing that marketplace of ideas to flourish, the natural consequence is misinformation. And when you, I'm giving the short term and the long term right thing, hard thing to do. But what unfortunately seems to be the trend, not just the Karnataka government, other governments, let's just use the stick of criminal law because it looks like we're doing something. It looks like we're achieving something, and everybody likes the swing of a policeman's baton at the people they don't like.
Okay, Manu, if I can come to you, similar question. But I mean, as somebody that's been at the forefront of a lot of this litigation playing out in courts as well, right? So it's largely the same question. It's the what is the existing framework? What is the problem with it? And I'm also trying to understand. One of the things that Alok flagged was that institutions are broken, right? And here we're having a conversation in the context of a center versus state, perhaps, but there are other institutions, including courts, the executive doing its own thing. So maybe you can start us off with that. And
I think there is a reasonably effective legal system to deal with at least certain kinds of misinformation, disinformation, by whatever nomenclature called. It's of course central law as of today. The central law permits more than one way of having information not available if that information is believed to be incorrect. So there is a legal way today. The second, of course, which Alok believes is not the right way, there is the criminal law for that kind of misinformation which results in a crime. Why is it that there is a new law that is necessary? To a certain extent, I agree with Alok that if a person who has deliberately put information that is harmful and that has resulted in chaos is never truly prosecuted, is never truly brought to the book, then having new laws, making new institutions is not going to solve the problem. That is one. Two, the biggest problem with the present approach as I see it is, the elephant in the room is the government wants to be the arbiter of truth. That's a little difficult to digest. That has never been and perhaps will never be. Two, purely as a lawyer, the central government tried it. They set up what is called a fact check unit. The Bombay High Court struck it down. SLP is pending for months together. A very beautiful long judgment by Justice Patel. Let me just read two sentences from that judgment. Nobody, I think, either on this panel or the judges who struck it down thought there was no problem. Everybody says there is a problem, but this is what the court says. I should not be misunderstood to suggest that the problem of digital fakes is not serious. This is, to be sure, noisy, raucous and a messy business. But that is the nature of a democratic republic with ensured freedoms. The cacophony of dissent and disagreement is the symphony of a democracy at work. So when there are competing values, then I think the buck can only stop at that kind of misinformation, disinformation that creates in actual harm. And those people who create actual harm must be brought to the book. Any bigger regulation than that will, I think, strike at the root of democracy. And in the current legal system, a very similar approach has been struck down by a court.
Malavika, if I can come to you before I move to Jayna and Sudhir to talk about the remedies envisaged here, but I want to take one step back and have in some ways, the elephant in the room conversation on the constitutional questions. Should the state government be thinking about this? This is not the first time that we've been having conversations on this idea of ring fencing state powers, central powers. Most recently, we saw this in the context of gaming, gambling, similar questions around, to be loyally legislative competence, right? So I know you and Alok have slightly different views here, but if you start us off and then we'll see which way the panel is going.
Yeah, thanks. I don't know Alok's views, so let me just trigger him into sharing. I think that with the hate speech law, it's a separate conversation, and we're all still sticking to the disinformation, misinformation question. So I'll stick to that as well. The state list allows for laws on public order, right? The state list allows for laws that concern the police. So the entries 1 and 2 of the state list automatically create an opening. But there is also the concurrent list we seldom think about anymore because we think it's sort of a de facto union list and the union claims it as willy-nilly. But the concurrent list also allows us to enact criminal law if we are going along with the proposition that these should be criminal remedies. The concurrent list allows us to enact laws on actionable wrongs. And the logic of the concurrent list was really that things that are provincial in nature or of provincial concern be left to the provinces to legislate, let them experiment. Maybe something is grand and fantastic, works really well, and then the union can enact a uniform law for all states. I think we've sort of let that logic go, and maybe it's useful to then help states make their legislative drafting a little cleverer so that laws that come through state list and concurrent list fields can survive the inevitable onslaught from union list entries. And I think Article 254 repugnancy is like the clean legal answer, but then you need really clever legislative drafting.
Our audience what article?
Right. Article 254 is the provision. I apologize. To be completely legal again, Article 254 is the provision in the Constitution that helps us reconcile two conflicting laws, one enacted by the union and one enacted by the state. And it creates a mechanism that says that if the state law is repugnant, then the union law will take precedence, unless, of course, certain conditions are fulfilled, in which case the state law can also then hold the field. But Article 254 is just a mechanism to resolve repugnancy. I think the real first principles question is, why not claim a concurrent list field to begin with as a state, right? And the first principle reasoning is actually in Article 73 and 162 of the Constitution, which says executive powers in the concurrent list by default lie with the states until the union enacts a law to claim it. And I think that these are just like first principle ideas that states should probably hold as good tools in their hands, and then make legislations cleverly drafted enough so that they survive the inevitable legislative competence challenge. It doesn't seem to me to be the biggest worry, especially because only one part of these laws is tackling this online. A lot of these laws is just participating in this ecosystem as individuals might for perverse reasons. There's also a separate whole conversation to be had about regulating the intermediary, but I'll let somebody else get to that when the time is right.
Okay, we'll come to that. Sudhir, if I can bring you in here. Wondering if you had a quick initial response or thought to build on this concurrent list idea that Malavika is talking about. That's one. There's actually a 3-part question. My second is, one of the anxieties that I have as we start, and I know that in this context, it's not just, the digital and the online is just one part of it. But one of the anxieties that I have with states starting to regulate the online sphere is perhaps a fragmentation and different standards emerging across different states. And I don't know if this is far-fetched or if this is a possibility, but if it's an online speech issue, then sitting in Bangalore, if I'm saying something, is the standard different? If I'm sitting in Bombay, that's part 2. And part 3 is just taking this further into questions of state capacity, perhaps implementation. How does some of this play out? Are there challenges that emerge or not? But yeah, feel free to take these in any order.
Yeah, thanks. Yeah, thanks, Neha. So I'll go at it in that order. The concurrent list question might be interesting from a sort of constitutional law point of view, but I think that the state drafts, and I know we're not going into the drafts in great detail, are quite clearly located in the public order end of the justification. So it just seems, without knowing, I mean, it's not like I have any inside information about what the government might be thinking, but I think it's an entry 1, entry 2 kind of legislation in the state list. So I don't think that the threshold problem of competence is going to be the big problem here. I know that there is litigation in other areas that is testing these questions, but just from a general point of view, I don't think that the competence question is what should detain us. It's prudence rather than competence. I think that all things said, state might have competence to pass laws on hate speech and on misinformation that causes harm. To the question of fragmentation, I think that there was a question from the audience about, what if the post is from Mumbai kind of question. And the territorial jurisdiction question is one that is a difficult one across all internet laws. So there's nothing new with respect to these laws. It will be a replay of the debates that we have had on internet law jurisdictional issues generally. But I see something else that maybe what the state of Karnataka, because I saw a lot of conviction in what the minister said. I initially thought that the draft might not be top priority, but it seems like it is top priority. So then I think that the best case that one can make is that you see what happens in complex federal countries like the US. Is you have the California effect. California becomes the default model of regulation. Something similar might happen. If Karnataka legislates, then a tech company would do well to just comply with the most stringent law, and then that would become a national standard anyway, a default national standard. So my sense is that the fragmentation as a matter of tech policy, the tech companies will work around that. That might not be the big issue. It's the prudence question once again that remains. And if I can just do that and kind of pick up from where Alok left it, I want to make a point of distinction, because Alok leaves it at the default model for free speech regulation in currently. And the default model is, if you don't like speech, you fight speech with more speech or better speech, right? So this is the standard marketplace model of speech. But the marketplace model of speech, which has worked sort of for the better part of a century and a half, relies on certain background institutional possibilities. And these are institutions of truth and institutions of fact-checking, the university, the expert, the media. If these guarantors, in some sense, or gatekeepers of truth and expertise perform their function, then the marketplace of ideas contestation model works out. So even at the best of the last 150 years, most misinformation studies would suggest that traction, say flat earthers, people who insist that the earth is flat, they would get traction at about 3% of the population, maybe some other more plausible position might get up to 20%. But we have a problem today. Today we have a problem that we can touch 50%, if not more, on this version of what is the truth and what is false. And here we have a problem. And what is that problem? And clearly that new media breaks the old institutional safeguards. They don't work anymore. The old marketplace model relies on these institutional safeguards. Now what do we do? And we don't have new safeguard institutions that have taken the place of the old institutions. So I think that is the kind of sense of moment of where we are now. And the way I think about this proposal for this legislation speaks in this context. That look, it would be great if the media and universities and experts were to moderate the spread of falsehoods. They're not doing it, so let's do something about it. And I think that's the kind of instinct, and that's where the push for regulation comes from. And let me just close that point by saying that I'm not suggesting that we should abandon a marketplace model of speech that fight bad speech with good speech or better speech kind of model. I'm not suggesting that, but I think that the cranks of regulation need to turn. And if we sit back and just say, oh, the old marketplace model is great, we should just all go back to that. And anybody who doesn't embrace that position is somehow acting or speaking in bad faith. I think that's a odd position to take in our times, is my sense. So for me, the unit question is very important. Is the unit of liability the individual or the platform? And I think that we're not having enough of a conversation about that.
Do you have a view on what
I
it
have
should be?
I have a view that maybe we need to do both. The minister seems to think that the primary unit is the individual, and we could do both, Alok. We could educate individuals. That's the long view. But we might need a liability rule as well, because that's the short view.
Manu will have a response to that. But,
and the last point I want to make is that platforms need to be part of the conversation. I mean, and there too, they must do more in terms of their initial truth and verity kind of safeguards, but maybe we need liability there too. So my sense is that is the kind that would take us away from hopefully a criminal law focused model.
Okay, Jayna. A bunch of things. I mean, I like that I really like that framing, so I'm going to stick with it. The question of prudence is the one that we should be asking. Again, I have a 3-part question for you. One is on the prudence, if I may, of the criminal law remedy. It's something that personally makes me quite uncomfortable. The idea of criminal ramifications, like free speech plus criminal ramifications is equal to very sort of uncomfortable for me. So if that's something that you could reflect on too. Rich body of, I don't know how much thinking we're doing about relying on free speech discourse, whether from the Supreme Court or otherwise. What are the limits on free speech? What is constitutionally permissive, not? Whether we ground it in this text or the drafts that we have seen, or even larger conversations, I want to see whether we're being true to that and really what we're allowed to do within that framework or not. And Malavika, maybe you can come in and opine on that as well. And the third is, given all of your body of work working with marginalized groups and communities, invariably when you have harmful speech, hate speech, essentially you're very often one of the folks that tend to get most affected or most targeted will be a marginalized group or community in some way, shape or form. So is there something that we can draw on from, I don't know, equality jurisprudence, anti-discrimination law that will help us think about some of these questions maybe slightly differently? And then Malavika, if you want to come in on the free speech question before I put Manu in the hot seat for the intermediary liability one. But
yeah, thanks, Neha. Very interesting questions, and I'll try to respond to all of them. Maybe go backwards and start from your third point. So when you talk, I mean, and I would like to look at the hate speech bill really from that point of view, from looking at it as an anti-discrimination kind of legislation. And some of our earlier efforts at CLPR were, 3 or 4 years back, we had drafted an equality and non-discrimination bill which contained hate speech. And I mean, if you look at equality and anti-discrimination law debates, hate speech is a form of discrimination. Hate speech is seen as a form of discrimination. And so in that sense, I would say that a law to prohibit hate speech would really be understood as an anti-discrimination measure. Now, when you look at, of course, this is a criminal law. It provides criminal remedies. If you look at your question of, vulnerable groups, yes, they're already targeted. And so how do you address that? I think, at least, I mean, if we just, foreground our conversation with this draft really addresses vulnerable groups, and it lays down, if there is speech made against a person or a person from a group from certain vulnerable communities, and therefore protected characteristics, protected grounds are laid down, religion, race, caste, sex, gender, sexual orientation, etc. So I think that's a good framing of a law, because really hate speech is targeted against people from certain communities, and therefore those protected grounds need to be laid out. I would, in fact, even if we were referring to this bill, I would say that a ground of political opinion or belief needs to be included, because often hate speech is made because of someone's political views, and that should also be a protected ground. And also people who are across different characteristics. You can be someone from a particular religion and particular gender. We have seen that, right, in multiple instances, whether it's the hijab case or against Muslim women or against people from multiple having different characteristics. So I think that's very important. The second issue was, you raised the issue. I go back to your first question about the criminal law remedies. This bill is makes this an offense, a criminal offense. In a way, it's an easy solution, like Alok said, and also it kind of fulfills your reasonable restrictions requirement in Article 19(1)(a). One of the grounds for restrictions of free speech, reasonable restrictions, is if it incites an offense. So therefore, the criminal law remedy fulfills that. It's easy to file criminal cases, but it also has a downside. We know criminal law remedies are often, while it's easy to just put a criminal law remedy, it also will make really the law unworkable in many ways, because criminal law remedies are hard for people to exercise. We know how difficult it is for vulnerable groups to take police protection. We've seen how the Atrocities Act even makes even registering of an FIR quite difficult if you don't have the backing that you need to engage with the police. So that is a problem, and therefore one of the measures I would also say, which a lot of other anti-discrimination laws have, is also have civil remedies. If you're saying that not just prosecute hate speech crimes, but also seek injunction remedies. If hate speech is put out digitally, electronically, have the remedies of going to court and getting injunctions to pull them down or to stop further speech. So I think civil law remedies should also have been there. And finally, I come to the free speech constitutional limits. I think free speech limit, reasonable restrictions are provided. So if there is an argument made that this legislation is a violation of the guarantee to free speech and expression, I think those restrictions in 19(1)(a) are there, that if it incites any criminal offense or public order and morality, those restrictions are there. So I think that would cover it. There are guarantees that, if they're well framed, that fair reporting, truthful media reporting, critical comment, or those exceptions that are there for art and critical comment and scientific reporting and all of those. So I think if those limits are there, courts have in fact stepped in and permitted such restrictions. So I think that should not be a problem. But I do see that having just criminal remedies would limit the use of a legislation if we're really looking at it as an anti-discrimination law.
So we should
be
keep
broader
criminal, but
remedies.
also add other
Certainly.
remedies.
Also add civil remedies, which can be used in situations where you do want certain harmful speech to be removed. The criminal law remedy would not address that. Right?
Sure.
How do you ensure that the speech is ultimately removed? And today, unless those remedies are there, you just have defamatory laws, or only the person who's affected can go to court. Here, if there is a harm, it would enable, if those civil remedies are there, it would also enable others to go to court to pull down certain forms of hate speech.
Got it. Malavika, anything that you wanted to build on here quickly? And Manu, I'll come to you with a bunch of follow-ups on this.
Yeah, just one quick thing. If you close read the judgments that make the transition from Ramji Lal Modi all the way to, let's say, Ram Manohar Lohia and then Madhu Limaye, these are at least 15 years of jurisprudence that are extraordinarily well written, that tighten the way in which you might interpret a 19.2 restriction, right? And what I've noticed in several laws that are being drafted in the last 20 years of this republic is that we sort of just lift the language out of 19.2 and drop it into the legislation rather than attempt to apply the standards laid down by these cases cleverly and tightly draft the laws so that the legislation then is actually an application of the 19.2 standard rather than a verbatim reproduction of
Why
the 19.2
is it a bad
standard.
thing? If I can, I mean, simplistically, if I can ask
I
you,
shouldn't
why
be
is it-
daring to say this in front of so many jurisprudence people in the room, but the thing I think about is from law school. Was it Ronald Dawkins who said that you can set up a principle or a broad standard as a concept, but the conception then is an application of that concept, right? And it can't be that you leave the broad standard to the interpretation of a trial court or a district court judge or an executive authority that belongs in the little body that the minister was mentioning earlier today, right? How many people even understand what it means to figure out if there is a proximate connection to disruption of public order? And now, cut forward to Puttaswamy, a proportionate way to take down content that could potentially disrupt public order, right? It's just too big of a legal analysis to just leave with in the interest of
In the
public
interest
order
of-
in the statute.
Yeah,
This
I'll
is
just
giving
add
you
to
lots
a
of
point
anxiety,
that Malavika made. I think this is why I believe Shreya Singhal was wrong. The judgment was wrong in upholding 69A because they saw the words in the constitution reflected in the statute and they said this is constitutional. Actually, it's not because Parliament has effectively delegated interpretation to an executive body. That is why it's unconstitutional and Shreya Singhal needs to be relooked. And that error has had consequences. The consequences being that free speech is now at the mercy of an executive body, sitting somewhere in Delhi. We see all these arbitrary blocking orders, not just in Delhi. It's at the mercy of every policeman in this country. The kinds of authorities who have been authorized to issue blocking orders is nonsensical. So I think on that front, I think if I want to, law students, others, please write more on this point that Shreya Singhal is wrong on the point of upholding 69.
Wow, I thought Manu would be the first person to bring up Shreya Singhal. Otherwise, I thought I would be the one to bring up Shreya Singhal. But Manu, wow, there's so much to respond to. Shreya Singhal thoughts, of course, obviously. Sudhir had brought up the point on the liability of platforms. Shreya Singhal obviously plays a role here, but larger questions on the limits of intermediary liability, whether in India or abroad. That's one. But I also want you to talk a little bit about some of the practical stuff, right? The point that Alok was just making in terms of it's really difficult as a platform receiving a slew of government takedown requests, blocking orders, etc., etc. How does that play out? Because invariably much of this ends up in court as well. So this is actually the practical reality of our times in many ways. And if we're thinking about all of this and we're thinking about new statutes, new regulations, how do we factor all of this into our thinking? A bunch of questions there. Second is the point that Jayna was making on remedies. Curious about your view on criminal remedies. Some of the civil remedies that she was talking about do find a place in the IT Act and a bunch of others. So if you could talk about that as well. And then maybe I just want to come back and do one round here before then Mal looks at me more sternly and gives me time check.
So, starting with platform liability, let me first talk about conceptually what Sudhir said, which is we have to reimagine more speech is the answer to bad speech. There I agree. But the logical development that government-sponsored version of right speech is the answer to bad speech is clearly for me frying pan into the fire. If the back of the institutions that control truth as we know it, for example, the universities, like Alok says, is broken, I'd hardly believe the government. In this room, if there is anybody I believe, that will be Sudhir. And certainly not a committee of government empaneled experts on what is truth. So therefore, I think it's a dangerous, slippery slope to allow government to narrate what is truth. That is one. Two, when it comes to liability of platforms, I just think because I have worked for so long with them, the first question should be, are they doing something at all? And from what I know, they are doing quite a lot. It's just that what they do voluntarily is not easily known. It's all out there. There are transparency reports that everybody publishes. It's just not out there. I think today the platforms voluntarily do so much to the point that if they did anything more, it will tilt the balance where protected speech starts getting shredded. I think they're already doing that. So therefore, the first assessment has to be, is somebody doing enough? And the second is a bigger question. Can we really afford to shoot the messenger and ignore the bad actor? Because ultimately it's the bad actor who's the cause, not really the messenger. Just imagine the world where today, for good or for bad, I can wish Amitabh Bachchan happy birthday. Maybe he will even acknowledge. This was impossible without social media. My concern is we start regulating the platform and all of this becomes impossible. I don't think that's a world we want to descend to. The problem's real though. Third, on crime and civil remedies, there are civil remedies. There is more than one civil remedy. Again, for example, they have constituted what is called a grievance appellate committee. Somebody is unhappy with some information which genuinely does not deserve to be there. One can go to the grievance appellate committee. It's a fast remedy. Now, whether it's a constitutionally correct method of doing it is another question. But is it out there? It is out there. So a large amount of bad information is being tackled. There are legal mechanisms. There are simple, inexpensive civil remedies, and injunction, like ma'am said, is always available. What I think the state, however, cannot do is move away from the crime model. Because once the state does that, they go away from public order, and there is one Supreme Court judgment on the point. It's on a concession, but Supreme Court says information technology is residuary. It's on a concession, but therefore the state begins with an uphill task if they move away from a crime model. I don't think means competence will be a big challenge there.
So basically, for competence, you it's a little bit like if you move away from the crime model, you're getting into questions of whether there is competence.
Just regulating speech online, and that I think current jurisprudence is heavily tilted in favor of the center.
Okay. If you had a quick response to this on any of the sort of, especially this sort of civil remedies question and the appropriateness of it, that's one. Second is, we've heard from more than one person this idea of marketplace of ideas and what kind of, this, a certain kind of, I don't want to say good speech, tackling bad speech, etc., basically counteract speech with speech. And again, the same framing that I gave you earlier, effective, how does it work? In the context of very, very harmful speech, marketplace of ideas model may not necessarily work. And maybe just for a quick sort of closing comment, the last one that a fairly open-ended question in terms of, if I could ask you to point to one, and I know this is difficult, one specific challenge, right? Should we be looking at getting the law right? Should we be looking at a question of institutional capacity? Is it a question of enforcement, or is it a question of center-state relations?
I'll just quickly respond. One is on the remedy model. Yes, criminal law is a way for the state to ensure that they can make the legislation, but I don't think that precludes including other remedies. We have now a slew of legislations that provide both criminal and civil law remedies, so I don't think that precludes it. Responding to the, I'll just take it away a little bit from your question, responding to what Manu said about platform liabilities and intermediary liabilities. I think the argument also that Sudhir made is not to shoot the messenger and let off the actual speech maker, but it's to make both liable. And today I think we have to find ways in which the law can address that. Yes, platforms and intermediaries are taking steps, but we are still seeing real life what is real life experiences of people who face hate crimes daily. I mean, you can take you can take any number of examples. You can take examples of Muslim women journalists who are given rape threats online, right? While you do prosecute or take action against the person, if you can decipher who that person is, but also against the platform, right? So I think so I think the law has to address both. And finally, the question that what about enforcement? How are our institutions going to enforce such a law? I think that is going to be a challenge. One of the biggest challenges would be, I would say, not maybe legislative competence or maybe even the challenge to the constitutionality of a law. But I think the bigger challenges would be when action is taken under this legislation, whether it's criminal or civil, how courts intervene. Today, we know that in criminal law remedies, how courts are intervening. Are courts going to be able to interpret hate crimes or acts of hate speech in the manner in which the law envisages, or are courts going to come and thwart criminal actions? We see quashing petitions, we see courts overturning even injunction orders. So really the big challenge would be in how our courts, whether they are the sessions court, district courts, or the high courts, in how they really interpret. And so that is going to be also a large institutional challenge that we have to look at.
Okay, Sudhir, I know you have a mic up.
Yes.
Bunch
No,
of things
I thought
to
you said
respond
you're going to
to.
go this way. So
No, but then I thought that I'll finish off that debate there. But a bunch of things that you wanted to respond to, closing comments. And I think maybe your closing question, if there's one takeaway, one thing that governments should keep in mind as they're thinking about regulating online speech.
Good.
But of course, anything else you want to respond to?
No, I will come to that. So let me just go at three points that I'd like to make, just drawing on the conversation that we have had and looking at the bills. The first is that we should detach the conversation about hate speech and misinformation. And I think that at the level of justification, both conceptually and as a matter of practice, they work differently. So we should not club them, and we should be very careful in keeping the two apart. I thought that the minister spoke primarily about misinformation, but I think when he sat down, he spoke about hate speech. So I don't know which of these legislations is going forward, but we might think differently about the two areas, is the first point. But my response to Manu is that we have a right to free speech, but nobody has the right to amplification. There's something conceptually wrong in the way the platform argument is made. You have the right to stand at the street corner and shout about whatever you want to shout. But you don't even have the right to use a loudspeaker. As you well know, in public space, the decibel levels of what you can use to shout is regulated. But somehow, on the question of digital space, we seem to assert a right to free speech which extends to a right to amplification. Nobody has such a right. There is no such constitutional right. And there is a way in which there is deep confusion about the scope of the right that leads to all kinds of arguments about why platforms are somehow immune to regulation in this space. So I want to make that distinction. I mean, we could have a longer conversation about it, but for now, I'll just leave it as a short point. No individual citizen can assert such a right. No platform can assert such a right. So platforms have to take responsibility, not for the content of speech, right? Because it's fair that new media platforms are not generative of speech. They are only channelizing speech. But they have to take responsibility for that and amplification. So I don't see how we can somehow exempt them from any of that. The single takeaway, so you said, the single takeaway that I would press for is to abandon the criminal law model. And here is a thought, and it's a conflicted thought. As a university administrator, I often am confronted with forms of speech that people want to take action against, which are simply unconscionable, if not criminal. But we find that working the institutional mechanisms of taking action doesn't really work out, doesn't work out so smartly in the criminal law otherwise. So my sense here is, yes, we have a reflex that we say that this is such a serious issue, hence it must be a crime, and we should break that reflex. And the costs of criminal law enforcement against speech, ultimately it's speech. If we take the criminal law to speech, it's a sledgehammer. The negative effects of the criminal law are severe, and if anything, we as a country should recognize that we haven't done too well with the use of the criminal law against speech. So that's my single takeaway. At the very least, the government should not create new offenses. If all that they are trying to do is to say that we will create an institutional mechanism for better enforcement, that's okay. We already have enough criminal laws on speech. Okay, they can focus on that. Maybe. My takeaway is no more criminal law on speech, I think, is a strong principled position that we could take.
Alok, quick closing comments. I know there was a bunch of stuff you wanted to respond to.
Very quickly, I think on the constitutional competence, if you see list 3, criminal law expressly excludes list 1, list 2 elements. So the moment it has been considered that information technology falls in residuary list, you will not be able to use criminal law to make legislation. Just want to respond to that one point. Second point, on social media, they're no longer messengers. They are participants. They choose what you see. So social media, whichever platform, the moment they move to algorithmic feeds, they are deciding what they want to see. And they know whatever triggers an emotional response in you, especially if it is, and it excludes to both hate speech and misinformation. They are amplifying it because they know it triggers an emotional response, which makes you engage with it. It is part of the business model. And I will go so far as to say they're equal participants in all of this. They are not messengers anymore. Let's do it with that. Third and final thought. In law school, we were correctly taught that criminal action starts from complaint and ends in conviction. No longer true. Or at least maybe it wasn't always. Now I have realized it, so I'll share my knowledge. Criminal action in India starts with arrest, ends with bail. So when we are saying criminal law, criminal action, let us be aware of that reality. What is provided for in the CRPC is good and right, but that is not honestly in the mind of a lot of policymakers. Having been in a lot of these rooms, they're content if they can arrest someone. And they're content if there is a ground to deny bail. That is it. They are absolutely uninterested in conviction. And we see that happening in the context of Umar Khalid and others. The state is not moving forward to convict anybody for this. They're more interested in, I can deny bail, that's enough for me. So there is no reason why the same pathology will not apply to free speech, as Sudhir has rightly pointed out, which is why I fully agree, you cannot use criminal law for this. It is platform regulation, should at best be done at the center without a criminal law framework.
Okay. Manu, I'll come to you for the last word actually, but Malavika, quick closing.
I just want to, on the principle that this is speech after all, quote something that Tarun Khaitan has written recently, just 2 lines. Freedom of thought is meaningless without access to truth. The unacknowledged harm of social media is to one's cognitive autonomy, which is the freedom to think not what I want to think, which is how we classically think of speech, right? What I want to think, I should be allowed to think. Cognitive autonomy is not the freedom to think what I want to think, but rather what I could have thought if I had real access to truth or knowledge, right? So in this attempt to create verity as a plausible societal value for us, we can't keep hammering at speech in these other ways through this hate speech bill, is my thought.
Manu, last word.
To answer Sudhir's point, I think there has always been a right to amplification. The right to press is a right to amplify my view. What I write reaches 1 million people from the time newspapers were printed. So therefore, it's not new. Unless I've misunderstood something, there always was, and that right was available to the select few who had access to the press. Today, that right is available to a non-entity like me. Therefore, the right to amplify has been democratized rather than restricted. And it's available. The moment it says right to press, it includes all of this. That's 1. 2, to respond to Alok on algorithms, there are 2 very nuanced judgments of the US Supreme Court which deal with this issue. 2024 and 2025. They deal with what algorithms do. They look at the law that is prevailing and come to a conclusion that, notwithstanding the fact that there are algorithms, still the errors of making disinformation available cannot be attributed to the platform. Now, I am not saying for a moment that that's the only view, but that view is already out there, because algorithms are a fact of our life. Today, whether I go to Netflix or YouTube, algorithms are at play. So therefore, to say because there are algorithms at play, you become responsible, may be an extreme view. There has to be a nuanced view.
Okay, wonderful. Thank you for that. I know you wanted to respond, but I'm going to request that we take this offline and take moderator privileges to invite the second panel. You guys have all been very patient. I know we're running late. I think we need to take one picture. Sorry, one housekeeping. But Shabunti, if I can have you up, and if you just want to get the other panel up on stage. Thank you, everybody.